Charged with continuous violence against family. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Welcome to the Court of Justice.
The court is calling 2017 CR 8433W, State of Texas versus Adriana Harrison. Could I have parties announced for the record for the state?
Catherine Pollard for the state.
For the defense?
Cornelius Scott.
And are you Ms. Harrison?
No.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Adriana Kiana Harrison who was placed on deferred adjudication in 2017 CR 8433W for the offense of forgery of a financial instrument on September 18, 2017 for a period of 4 years and extended for a period of 1 year? Is that you?
Yes, ma'am.
State?
For this violation of condition number 5 in Bexar County, Texas, the defendant, Adriana Kiana Harrison, did then and there fail to report to the supervision officer as directed for the months of July through September 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State?
Judge, we would waive the remaining violations.
No objection.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Judge, the agreement is to revoke and sentence to 4 days Bexar County Jail under section 1244.
All right, is that the agreement?
Yes, ma'am.
Are you asking the court to follow that agreement, Ms. Harrison?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court doesn't have a trial court certification. All right, are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will find you guilty. As previously stated, the court is finding violation of number 5 true. The court will grant the motion, sentence you to 4 days in the Bexar County Jail under 12.44. Give you credit for any time served, and the court will show that the judgment is satisfied. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Next, the court is going to call 2022 CR 10906W. Can I have parties announced for the record for the state?
Catherine Pollard.
Defense?
Cornelius Scott.
And are you Ms. Harrison?
Yes, ma'am.
Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all of the discovery in this case, and did you review it with your clients?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Next, I'm going to show you what's entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Did you understand that your attorney has a right to have the case presented to him and review the case, and has 10 days for preparation for jury trial?
Yes, ma'am.
Did you understand that your attorney also has 2 days from the presentation of the information?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled Information. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, ma'am.
State, are you proceeding on the information as presented?
Yes, Judge.
Going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with continuous violence against family? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, ma'am.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Harrison, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $1,500 fine probated. State recommends deferred adjudication. They will take in consideration NIMAG number 6694443, 679250, grand jury numbers 782104, 782105, 782106, county court cause number 639826. There's an affirmative finding of family violence, the BIPP course, and you received judgment sat in 2017 CR 8433W. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with the affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the agreement?
Yes, ma'am.
State,
Yes, Judge.
defense?
Yes, ma'am.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 5 years. There be 200 hours community service restitution and no contact with Taquidra, Taquiedra Evans. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Judge. We'd offer what's been marked as State's Exhibit 1.
No objection.
I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes.
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication or proceeding with sentencing.
Oh, we would like to, Judge.
Anything you wish to say on behalf of your client?
Just, we asked the court to consider and approve the agreement in this case. The only kind of unnecessary issue or request that we're just making, instead of having a no contact order, we would, our preference would be a no harmful or injurious contact with the witness.
All right. So it appears to me that your relationship with Miss Evans is over. It's concluded. You're not going to have any contact with her. I'm not going to allow that. Because anytime somebody needs a court to tell you not to be harmful or injurious in a relationship, you don't need to be in that relationship.
Yes.
So I'm going to explain to you as best I can. She doesn't want you anymore. Even if she does want you, I'm telling you, she can't have you and you can't have her because I'm not going to allow it. And if there is contact with her, you're going to be looking at 10 years in the prison. And I want to stress this, and I want this for you to internalize it. This probation, if I give it to you, it's a contract with the court. It's not a contract with the state. It's not a contract with your attorney. So if you all come in and decide, oh, she violated her probation, we're coming up to an agreement, I don't have to follow that. Do you understand?
Yes, ma'am.
So do you understand that your relationship with her is over?
Yes, ma'am.
Do y'all have children together?
Yes, ma'am. But, yes, ma'am.
I'm sorry.
No, ma'am.
All right. So there's no need to be in contact with her. Do y'all have a home together?
Yes, but I don't stay there. I'm moving.
No, I mean,
No.
are you on the lease?
No.
Are you all married?
No.
All right. So you don't have a relationship with her. There's no reason for you to be in a relationship with her. How old are you?
27.
All right. So you old enough to know that there are other people out there in the universe. And I'm sure that you've been alive longer than you have known her. So the relationship is done. It's over.
Yes, ma'am.
Do you understand what I mean when I say it's over?
Yes, ma'am.
And when I tell you, have no contact with her, that means you're not to call her. You're not to send her flowers. The holidays are coming up. You're not to send her a just because card. You're not to send her thinking of you cards. You're not to send her a happy Thanksgiving card. It is as if you do not know her. If you see her walking on the side of the street, or even think you see her walking on the side of the street, you better go in the other direction.
Yes, ma'am.
If you see her at the store and you think that's her, you better go in another direction.
Yes, ma'am.
You know how some people do that thing where they're driving through Starbucks or somewhere and they do a pay it forward? If you see her behind you in a car and you're going through a drive-in and you say, you know what? I want to pay the person behind me's meal. Don't do it.
Yeah.
That's what I mean by no contact.
Yes,
Do you
ma'am.
understand?
Yes, ma'am.
All right. There's a $1,500 fine. That's to be probated. 5 years deferred adjudication. Take in consideration NIMAG numbers 669443, 679250, grand jury number 782104, 782105, 782106, county court cause number 639826. There's an affirmative finding of family violence, the BIPP course. Are you employed?
I was until I got on full house arrest.
All right. And there's a reason why you're on full house arrest. There's going to be 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Parenting classes, once you complete those parenting classes, then the remaining of those hours will be waived. Proof of employment within 30 days. There's to be no employment as a home healthcare provider or with minors. There's to be no contact with Takirda. I know I'm saying the name different each time. I don't know if all these vowels are supposed to be pronounced or not, but it's TAQUIEDRA Evans. There's to be regular reporting by Zoom or in person. There's to be regular UA. If you're tested today, what are the results going to be?
Negative.
There's going to be field visits 2 times per month until further notice. State, with regards to the GPS, are you okay to begin with tracking, but with the curfew?
Yes, Judge.
But I don't think there was a GPS on, maybe I missed that. Continued GPS, she's been on GPS already.
Yeah, and since she's been on GPS, we haven't had any problems with her and Miss Evans.
Correct. No problem.
So, yeah, so we're going to do tracking, but I'm going to do a curfew. And your curfew is from 7 a.m. So she can leave the house at 7 a.m., but she needs to be back in the house by 7 p.m. If you have employment, then the court will consider increasing curfew with employment.
So it wouldn't be we'd have to come back to court. If say that if the job wants to work till 8 o'clock, then we have to come back to court to get.
Oh, no, she has to give proof to probation of her work schedule. And probation, she used to be on GPS tracking for 3 months. We'll see how that works out. If there's no problem and somebody wants it removed, then the court will consider it at that point.
We waive the fee. Well, the fees were waived. Will we continue?
Yes. All right, is there anything else?
Mhm.
All right, I'm showing you what's entitled trial court certification of, I'm sorry, probation. Is there anything else she needs?
With the GPS on probation,
All right, we'll defer it. All right, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney?
Yes,
Did
ma'am.
you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. Do you know what I mean when I say no contact?
Yes, ma'am.
Do I need to express that anymore?
No, ma'am.
All right, and that means no social media either.
Mhm.
No social media. I love you. You know, and no contact through third parties.
Yes, ma'am.
If that happens, we're not going to have a conversation. A motion to revoke is going to be presented to me. And if it's in proper order, I'm going to sign it. And we're going to either hear those allegations with you behind bars brought over, or either you're on bond. And then at that point, if it's proven to be true, you may end up going to prison for 10 years.
Yes, ma'am.
And so from here on out, anything you do, you need to ask yourself, is this something that could potentially get me sentenced to prison for 10 years? And if you have a question of maybe it will, maybe it won't, you probably shouldn't do it.
Yes, ma'am.
All right. Good luck to you.
Adriana Harrison stood before Judge Stephanie Boyd on 2 cases back-to-back. The first, a violation of deferred adjudication for forgery of a financial instrument. She pleaded true to failing to report. The agreement? 4 days in county jail under 12.44. Simple. Clean. Over. Then came the second case. Harrison was charged with continuous violence against family member Taquiedra Evans. She pleaded guilty. The state recommended deferred adjudication, a fine, community service, and a no-contact order. But defense counsel attempted a subtle pivot, requesting no harmful or injurious contact rather than a full prohibition. That's when Judge Stephanie Boyd took control. If you need a court to tell you not to be harmful or injurious in a relationship, you don't need to be in that relationship, Boyd stated plainly. Then, she lowered the hammer. She doesn't want you anymore. Even if she does want you, I'm telling you, she can't have you. And you can't have her. The courtroom fell silent as Boyd enumerated exactly what no contact meant. No calls. No flowers. No Thanksgiving cards. No thinking of you cards. No paying for her coffee in a drive-thru. No social media. No third-party messages. If I see you behind bars, and it's proven true, you're going to prison for 10 years. The terms of deferred adjudication reflected the gravity: 5 years probation, GPS monitoring, a 7 a.m. to 7 p.m. curfew, 200 hours community service, 40 waived for COVID vaccine proof, the rest upon parenting classes and employment, and no work with minors or as a home health aide. Boyd ended with a warning Harrison will not forget. From here on out, ask yourself, could this get me 10 years in prison? If the answer is maybe, don't do it. A defendant came seeking leniency. She left with her freedom, but only under absolute, zero-tolerance terms.